Sir, we are concluded now. Yes, Mr. Zibal. No, sir.
Sorry.
Thank you. Sorry. Sorry, sir. We have.
Sorry.
Thank you. All right. Thank you. Thank you. Thank you. Selfie arose out. Thank you. Yes, Mr. Zibal.
May it please your lordship.
What we have said has been said. The Chief Justice had to say has been said. We've heard both sides, I think, for 15 days, quite patiently. Maybe, not everybody can be heard in a situation like that. Don't try ever to browbeat the court. We will never try that with you. Either with the chief or with me, anybody you try that. Okay. Thank you.
Yes,
You
thank you.
said thank you. That's
Yes,
all.
Mr.
Next,
Sibal.
Mr. Sibal. Next matter.
Yes.
Yes, Mr. Sibal.
You're not appearing before a trial court. You're appearing before the Supreme Court. Yes. Yes.
Allow me
Mr.
to
Sibal.
argue, please.
Yes, Mr. Sibal.
No, Malas, at the outset, I wish to state, Malas, that this case has been argued at several levels. And Malas, most of them unsolicited, without reference to the arguments made by us. I don't think anybody on this side challenged the sovereignty of India. Nobody on this side challenged the sovereignty of India. I, Malas, at the outset stated that Jammu and Kashmir is an integral part of India.
They say your first petitioner has said something which are not in sync with.
But I'm not
argument.
concerned with that. If the first petitioner has said something, if he has said it, in what circumstances he says it, is it recorded? You ask him for an affidavit. I have nothing to do with it. There are two petitions. Hold on. Let's not take time on that. One second. Let's not take time on that. I am not standing for him for what he said if he said it. I am not here.
Mr. Sibal, do we take it that Mr. Lone therefore unconditionally accepts the
Malas,
sovereignty of India and that Jammu and Kashmir is an
He is
integral
a
part
member
of
of Parliament today. He has sworn to the Constitution of India. He is a citizen of India. How can he say otherwise? And if anybody has said it, Malas, I, at my level, deprecate it.
No, it
Malas,
is
what's
one
the
thing
point
for
of-
Mr.
let's
Sibal
not-
to deprecate.
Let's not go into an issue.
A
Malas,
litigant before your lordships.
ask him to file an affidavit. Then I have nothing to do with it.
No, but it's your client. You have to ask.
I don't know.
He
You are
must
making
file
an
an
allegation.
affidavit.
I
He
don't
will
know.
not support terrorism.
Right, let them reflect on it.
If you don't mind,
Mr.
take
Sibal,
it on the pleadings, ask him to file an affidavit. I may
it
not,
is on
it not
affidavit.
appear for him. I don't know, Manas. Why am I, what have I am not to answer what an allegation that is made.
Because Mr. Sibal, when he invokes the jurisdiction of our court under Article 32 of the Constitution, he therefore necessarily abides by and owes allegiance to the Constitution.
He's a member of the Lok Sabha. He is
How
sworn
does
to the
that matter?
Constitution of India. He's a citizen of India.
How
One
does that
second,
matter?
Mr. Sibal. But that's one second. That's a submission, Mr. Sibal. But we want to have it from him that he unconditionally accepts that Jammu and Kashmir is an integral part of India, and that he abides by and owes allegiance to the Constitution.
Of course,
And does not
he has
support
sworn to it and he
terrorism
became a member of the Lok Sabha. Manas. He swore to it.
Mr. Sibal, because then when you argue and you accept, as far as sovereignty is concerned, you accept the sovereignty of
Of course.
number one, the people of India. Number two, that J&K is integral part of India. When you argue, your client says something outside the court, something different to it, there's
But
contradiction.
still-
And probably
till-
then, he's also accepting there was a issue and a problem which had to be dealt with.
Manas, if I start, Manas, recounting,
No, I'm not saying
what
that,
may
so
have
be
happened-
clear on that.
Manas, it will unnecessarily lead only, Manas, to a media coverage. Let us not go that route. We are arguing a pure constitutional issue.
No.
If, Manas, there is a speaker of the BJP who was present there when this allegedly happened. There are some people who asked him to say something which he did not say. Why do you want me to go into all this?
No, please go into it. I have no difficulty. Lord, there is
It
an
is not
affidavit.
part of the record. It has been withdrawn. It has been deleted from the record. It is said in the Yeah, what is all this? It was said in the assembly, the
affidavit of Mr.
BJP
Judge says-
speaker was there, the speaker not of his party, the BJP speaker was there. He was asked to say something which people ask other people to say on the streets of this country. Why do we want to go into this?
No, my lord, we would insist, my lord, you must go in.
Therefore, we accept.
Of
we-
course,
we-
but
we-
unconditionally.
We proceed on the basis that he's willing to file an affidavit before our court saying that, well, he owes allegiance like every other Indian citizen to
course.
the Constitution of India, and that Jammu and Kashmir is an integral
Of
part
course,
of the country.
Maharaj,
because-
first of all, one
Aspect,
second.
Lord, I'm sorry for
Will
your
you
interruption.
allow me
Another
to-
aspect,
I
the
think so,
affidavit
yes.
mentions that in all public speeches of petitioner number one, he supports separatist elements and other elements. Let him say he does not support secessionism and terrorism. No citizen of this country can have any objection in filing that affidavit.
There's
That
another
I do
petitioner,
not support
Justice Masoodi.
terrorism and
There's
secession.
another petitioner, Justice Masoodi. Please allow me to argue.
No, that's.
For Justice Masoodi.
that-
You want to
that's-
take any action
that's
against the
very
gentleman, you
unfair.
take
That's
action.
Unfair to us.
Please don't derail a pure legal submission.
Hear it. We'll hear you for Mr. Loan as well. There's no difficulty.
He wants to have
He
it.
has come to our court. We are more than duty bound to hear his submissions, and we are in the course of hearing his submissions. All that we want to say is like everyone else here, because we have had people from across the political spectrum in Jammu and Kashmir who have presented rival viewpoints before us, different perspectives, which is welcome. That's why we are here to resolve those issues. But all of them have come here in one spirit, which is that they abide by the integrity of
You
the.
cannot be a member of the Lok Sabha and be a member there without abiding by the Constitution and an oath of office that I abide by the Constitution of India. He has to take that oath because he enters the Lok Sabha, as we all do.
That's what.
And there's an affidavit filed there, Malaj. How can that be? But be that as it may, Malaj, I did not know of this fact till this morning. Somebody
Just
raised
ask
it.
him to
Malaj.
file a short affidavit before us, a one-page affidavit. That's all that is necessary.
Lord, we are given a copy to Mr. Sybil's client, Lord.
We'll give
Everybody
the
has been
affidavit.
served.
There is
then-
no question, Malaj. I would not stand here. If he doesn't give it, I would not stand here arguing for him.
So before we close the argument
Yeah.
tomorrow, just ask him to file a one-page affidavit. That's all that we.
Have been
Yes,
taken
Lord, and
on
I
this,
would
Malaj.
request
We have
Mr. Sybil to insist to his client that no citizen would have any objection in saying that I do not support terrorism and
What is all this
separatist
terrorism?
activity. Let him say that, or say that I
Yes,
will
what
not
is all
say
this?
this.
What
Let
is
it be
all
clear.
this? What is all this?
Which he is supporting.
What is all this? Well, we will certainly, Malaj.
I'm sure Mr. Sibal will.
So we'll convey this to him and he will file a short
Malaj,
affidavit.
Had I known this, I would have myself.
See
Yes.
what affidavit.
Anyway.
Will you allow
we'll
me?
see Tomorrow.
2:30,
Once.
half
Yes,
an hour
yes,
is lost
Mr.
just
Sibal.
on this.
Mr. Sibal, yes.
It's not just on this, Malad. It is a serious issue.
What is a
the
serious
legal
issue?
is
But do
serious.
you want me to say something that I shouldn't say in court?
Well, he wants his fundamental rights to be enforced in his.
There are, everybody has fundamental rights in this country.
But you take a
including
concrete
including those who on the streets you vilify.
They are also wrong.
So then that's all right, then you should apologize for them.
All right. Yes, Mr.
So let me argue the case,
They
please.
are not.
Mr.
Let
Solicitor,
me
I
not
think the
represent
case,
them.
sir.
Mr. Solicitor, we have indicated to Mr.
Your
Sibal,
lordship
let
have
him
indicated
now
to
open
me.
the argument.
I
Let him
made a
open the
commitment that there will be an
Yes, Mr.
affidavit.
Sibal, you open the argument. now.
Yes, please. So, Malas, this case has been argued at different levels.
Yes.
And Malas, I was somewhat pained when one counsel argued that we respect the sentiments of the people of Jammu and Kashmir. But you must also respect our sentiments. Now, Malas, I think that we cannot reduce this case to an emotive majoritarian interpretation of the Constitution of India. Whereas all residents in Jammu and Kashmir are citizens of India, they are as a part of India as anybody else. If historically there is an article of the Constitution that gives them certain rights, Mullahs, they are entitled to defend that as a matter of law.
Yes.
That those rights may be taken away, may not be taken away, constitutionally or without reference to the Constitution is another matter. But to say that you must respect our sentiments as if they are somebody else itself is creating a kind of chasm that shouldn't be created, especially in court. That's number one. Number two, Malats, and I adopt Mr. Salve's argument, that we are concerned with the interpretation of 370. read the text, understand the context, and interpret 370. I entirely agree with that. And that's exactly what I'm going to do before your lordships. Number 3, Malaj, if you look at the history of India in that context, Malaj, you will find that Jammu and Kashmir had no links with the rest of India, geographically. No links. No part of the territory of Jammu and Kashmir was linked to the rest of India. And the two principles on the basis of which accession had to take place was contiguity. You have to be contiguous. That's how Malaj, states like Junagadh, Hyderabad, many other states which were within India could never accede to Pakistan because that principle could not be established. So you had to have contiguity, and you had to have population. These were the two principles. And the decision, the third, was to be taken by the ruler. These were the three principles on the basis of which accession took place. Factually, Jammu Kashmir was not contiguous to India.
How do you say that, Mr.
Because, Malaj, it is Radcliffe, when he came and he made the award, he gave Gurdaspur to India. That's how we got contiguity. That's part of the Radcliffe Award. Of course, Radcliffe, when he came, knew nothing about India. So you might appreciate, Malaj, what were the forces behind it. And Firozpur was a district connected to Gurdaspur, which had a Muslim majority population. Firozpur was also given to India. That established contiguity. That one historical fact, Malaj, your lordships may know. And it's part of the records, Malaj, of the case. The second grave issue that was confronting India at that point in time was Greater Punjab was Muslim dominated, not the bifurcated Punjab. The majority population was Muslim. If you gave Greater Punjab, or what was Punjab at that time, to Pakistan, their boundary would reach Delhi. Nobody could afford that. And if India got all of Punjab, our boundary would reach Lahore. Neither Pakistan would accept it, nor India would accept it. These are historical, this is a historical background in the context of which the fate of Jammu and Kashmir was to be decided. Note another fact. Jammu and Kashmir had a constitution, a detailed constitution of 1939, which had an administrative structure like any other democratic structure, except that the Praja Sabha was dominated by Dogras. In fact, all the nominees in the Praja Sabha were Dogras. Sheikh Abdullah, who had an egalitarian outlook, was dead against the ruler and therefore was imprisoned. There was a popular movement in Kashmir against Hari Singh. Sheikh Abdullah and Pandit Nehru were of the same bent of mind, because Pandit Nehru also showed utter distaste for the concept of rulership. In fact, it was Sardar Patel who said, we must honor our constitution. Nehru said, no, we shouldn't. We shouldn't give anything, no privy purses to the ruler. That's all a part of record of history. That's why when the invaders came into Jammu and Kashmir, Nehru said, release Sheikh Abdullah first. And he became the interim prime minister. He then was made a member of the Constituent Assembly of India to negotiate the terms of the details of the accession. And remember, the constitution of Jammu and Kashmir, like no other princely state in India, no other, I say, was drafted after 1950. And came into force, Maharaj, in 1956, 57. It was completed in 56, came into force in 1957. Only state, only princely state. That's one set of historical facts that your lordships must keep in mind. Second set, even more important. The Indian Independence Act was passed in Parliament in UK on the 18th of July, 1947. Originally, India was to be granted independence in May 1948. The date was preponed to 15th August 47. So after the Indian Independence Act was passed on 18th July, you had 12 plus 17 days to complete the process of signing 562, if at all, instruments of accession. On the 25th of July, note this date, that's why I said I needed to put it on record, because your lordships don't allow me. Because my learned friend Miller's filed 18 pages of written submissions and then 250 Millers. I tried to file 5 pages and I was told I cannot, but that doesn't matter. This is all part of the record I wanted to place, but it doesn't matter. I think your lordships should take it on record, but I leave it to your lordships. Anyway.
Is it the only thing that you want to file is now this 5-page submission?
No, that was originally which your lordship denied me at that time.
What
But
do you want to file now?
because he has made some list of dates.
Sibyl, what do you want to file now?
Nothing, Manoj, just basically I have to meet the arguments.
Fair enough, but so long as what you're filing is not much more than what everybody has so far filed.
No, Manoj, why
You
would
don't want to be confronted with a 300-page document.
Manoj, your lordships, I will not waste a minute of your lordship's time, Manoj.
So how big is it and what is it that you want to file?
38? 38 pages. There's nothing much.
All right. File the 38 pages, no difficulty.
Simple, we've even taken note of your earlier 15 pages. But if we had permitted you to file, the whole sequence would have.
I agree. I'm not complaining.
Everyone else would have then followed. That's
I am
the
the last one to complain. I never raised the issue. But when I was told that I can't file.
No, Mr. Sibyl, it was not meant for you. It was meant for everybody.
I know that.
So
But
don't take it
everybody filed.
that-
The problem is everybody filed. But neither,
But
there's too
Sibyl,
little time.
ultimately, we took down the need of having to record in
That's
writing
good,
what
that's-
we have argued, but now we've taken.
It's all
up
right,
this
no problem. So, Manas, the say, what? His list of dates, not mine. No, no, no. We have already added, your list of dates, I've made a blue mark. If you have had these green and yellow and that, I've just added a blue mark to your list of dates. That's all. Not my list
So
of dates.
their list of dates, as I recall, was about 110 pages.
10 pages. I've just added 5 pages to that, Manas, to give some correct date.
So the 115 includes the earlier 110.
That's right, that's right.
And 5 which you have added. Fair enough. That we don't mind. There's no difficulty. And you have followed the same format,
So
track
that
changes.
your
that
lordships are not.
we know what you have added at the end.
Exactly. It's in blue, Manas.
So long as otherwise, it becomes impossible when we are just to sit down and
I
dictate a
told them,
judgment.
Manas, we mustn't burden your lordships, and therefore we did it that. Anyway, so let's, Manas, move on. So, Manas, on 25th.
So just a second, you're filing therefore your list of dates, which
Yeah.
are 150.
And my written
pages.
submissions, Manas, in response.
The written submissions are 38 pages.
Yes, yes, yes.
So all that you are now filing.
There's an appendix,
one second.
appendix to it, Manas.
That total 67 pages. Submissions are 1 to 38, annexures are 39 to 67.
That's only appendix, Manas. That's an appendix data, Manas. That's all, nothing more than that.
What is the nature of the
Data, for
annexure?
example, he said reservation didn't apply to Jammu Kashmir. So I'm saying it applies. This is the article. So these kind of things, Manas.
All right. There's no,
For example, no education. Actually, education in Jammu Kashmir is free up to university. Free education till university. In the constitution itself. Manas, I mean, these are facts which should have been stated by the other side. They say there's no official language. There was an official language.
you can file it because
Thanks.
we now, it's 5 pages, basically 5 pages of list of dates
Yes.
added on.
Yes.
And your submissions about 38 pages. The annexure is to explain what, according to you, has been made available or what is.
That's all. Nothing more. And I want.
But in the same vein that you said, don't take into account what they have said on the more, should we say, developmental aspects. We shouldn't take into account what you have said also on what is available.
Exactly, Manas.
To answer the core constitutional issue.
Exactly. That's why I never went into that.
Sibyl, when you say 5 pages on the lighter side, my court, at least when I used to say 5 pages, if somebody handed over 10 pages, I has to remove the last 5 pages and
Yeah, right.
confine it to the first 5 pages.
Novelist, note another thing. On 25th of July, 1947, the Chamber of Princes met. This was. So, Manas, in the Chamber of Princes, Sardar Patel said, we will only have with us that the union, communications, external affairs, and defense. You are autonomous for the rest. 25th of July. 25th of July. That's also part of the record that I've given you. Mountbatten said it in the on 5th of July, he had said it also. So, Manas, therefore, and that was the understanding with the princes. It will be a federal structure, communications, foreign affairs and defense will be the union, and the states will be autonomous. That's one part. The other part was, Manas, there were some princely states, Manas, one of them, the only property it had was a well. He was a prince of that well, Manas. He had no means of livelihood. They naturally, such small states had to join larger princely states. Kathiawar, Saurashtra. Saurashtra had incorporated 220 princely states within it. The whole process of 17 days was an entirely asymmetric process. Idea was to persuade all of them to please sign instruments of accession. Epsu was one of them. Faridkot, Pesu, all those. That was happening, Mullahs, with Sardar Patel and VP Menon and Mountbatten, who had personal relations with all the princes, which neither Sardar Patel had nor VP Menon had. Because then the Governor General Mountbatten was actually served in India for a long period of time, and each of these princely states had a resident. And they would be told that you only should spend 10% of your revenue of the state on yourself, the rest you should spend on the public, but most of them spend 80% on themselves. But ultimately, they all exceeded. They all signed instrument of accession by 15th of August. With a standstill agreement and nothing more. Some of them who merged into larger administrative units didn't have to do that, because then they were represented by the larger administrative units. So my learned friend, the solicitor, is right that many of them, princes, did not merge because they were merged with other larger administrative units. So it was an entirely asymmetric way of actually getting them all together in 17 days. It was a Herculean task. Ultimately, who stood out? Hyderabad, Junagadh, Kashmir, and Travancore. In fact, the first ruler to revolt was Travancore. Yeah, because of the advice of the Dewan Mullahs, who ultimately got attacked and was in hospital, and then they signed the instrument of accession. But that's just the Mullahs. I know, I don't want to take it. And Mullahs, now you were left with Junagadh, you were left with Hyderabad and Kashmir. And as far as Kashmir was concerned, your lordship knows, the instrument of accession was signed subject to certain conditions. In many of the instruments of accession that were signed by with other princes had a provision that there can be a supplementary instrument of accession, but there cannot be unless I give consent. That is, the ruler gave consent. So some of them had supplementary, but this didn't happen in Jammu and Kashmir. The point that I'm making is, Mullahs, Jammu and Kashmir was the only state in India where a special dispensation was made for reasons which were domestic and reasons that were international. Which is why this whole argument that there must be uniformity is completely bereft of the historical context. Now, principle was contiguity and population. Junagadh acceded to Pakistan. Acceded to Pakistan. Somnath temple was in Junagadh, very dear to all of us. So, Mullahs, having acceded to Pakistan, India wanted to invade and take over Junagadh. Mountbatten said, you can't do it. He has acceded to Pakistan. This is foreign territory for you. So ultimately, Mullahs, infiltrators were sent. And they took over and there was no resistance. Then negotiations took place and Pakistan agreed to a plebiscite, a referendum. Knowing full well that such a referendum would happen in Kashmir also then. The same thing happened in Hyderabad. The ruler was Muslim. The people wanted to join India. But he did not join Pakistan. He wanted to be independent. He didn't accede to Pakistan. And there was a general this happens nowadays also. There was a freelancer who promised the ruler of Hyderabad that I will get you arms, you give me so much money. So they piled up a lot of arms to resist any invasion ultimately, Maharaj, that man, Mr. Cotton, left him and the invasion took place and be occupied. Now you're left with Jammu and Kashmir. Jammu and Kashmir, the population was Hindu, Muslim majority, and the ruler was Dogra. It is in this historical context that you must view what happened in Jammu and Kashmir was only to ensure that Jammu and Kashmir becomes an integral part of India. There can be no question about it. I'll come to that. Yes, I'll come to that. There can be no plebiscite in Jammu and Kashmir. That is our position. We stand with India. Now, Manas, having signed the instrument of accession by 15th of August and some of them standstill agreements, the question then was they had to merge because none of them had any administrative units in place. You had to have local self-government, and your lordship knows at that point in time, we wanted India to be a democratic nation. So then Sardar Patel and Menon persuaded all of them to please have merger agreements so that we can treat you in the same way as other provinces. So all of them signed merger agreements, not Jammu and Kashmir. Nor was Jammu and Kashmir asked to sign a merger agreement. Never.
How many merger agreements were there actually?
I'll give you the number, Manas. I think we have them. No, much less. Much less. I will give your lordship the number.
Because everybody who signed an instrument of accession didn't necessarily sign a merger, right?
No. Because what happened was, Manas, many of them
had formed unions with existing states
That's
like Kathiawar or Saurashtra.
That's right.
Pepsu.
That's right. You'll have that. Well, that's not an issue. So, Manas, that didn't happen in Jammu and Kashmir. So when the infiltrators came, Manas, and he couldn't defend himself when he went away from Srinagar, Manas, he ran away from Srinagar. And we helped him, Manas, by going there. The issue arose, we had no communication systems in place. No communication system in place, and we didn't know the topography. Our army, because we had never been there. The army represented that if you want to deal with the infiltrator, the source of it is Pakistan. So we'll have to target Pakistan, to which Mountbatten said that will declare war. If you do that, it will be war. You cannot be allowed to do that. So we were not allowed to do that. So the result was that in that situation, kindly remember, referendum is not the only place that we're talking about in Jammu Kashmir. There should be no referendum. There can't be a referendum in any case. But referendum happened in the northwest provinces. We had the Congress government in the northwest frontier province. A referendum happened there and they went to Pakistan. Referendum happened in Junagadh. So it is not as if this was alien to the concept of how people express their wills. But in our case, what happened was the government of India said, let the Constituent Assembly, namely the people of Jammu and Kashmir, represented in the Constituent Assembly, express the will of the people. That's how 370 came in. There was no other way to express the will of the people, certainly not through a referendum. Nobody wanted it. especially after the first year, because in 1953, Sheikh Abdullah was arrested by Nehru. Because he raised the slogan that we want to be autonomous. Sheikh Abdullah was arrested by Nehru himself. Nobody wanted a referendum. Nobody would have allowed a referendum. But the way out was, in that context, draft a provision in 370 by which the will of the people of Jammu and Kashmir can be expressed through the Constituent Assembly. That's the historical lay of the land, Mullah, in the context of which you have to read Article 370 of the Constitution. Now, Mullahs, let me disabuse your lordships of some of the myths that have been portrayed here. Number one, that Parliament has plenary powers under 370. Just the contrary. The power of Parliament to make laws is limited by 370. Nobody's read it. Just look at 370, madam, with me. Just please read 370 with me.
I don't think there are limitations on Parliament's lawmaking power because
No, not that.
Yeah.
Well, that I'm not saying that. Well, I'm saying something different. Just read 370 with me. I'll read it with you. Yes. Notwithstanding anything in this Constitution, the provisions of 238 shall not apply, and the power of Parliament to make laws for the said state shall be limited.
what are you reading? Which
Article 370.
270?
It is a limitation on the Parliament to make laws. Yes, 1B. To matters in the union list, to matters in the state list, in the concurrent list. It stares you in the face, and you're talking about plenary power. Where is that plenary power? If you want to pass any law, or if you want to extend the provisions of the Constitution of India, forget about 371 B1 and 2. Look at D. If you want to extend the Constitution of India in respect of matters which are in the instrument of accession, outside of those matters, you have to consult, otherwise you have to take concurrence. And how does the President of India act? On the inner advice of the Council of Ministers. President is not acting in his individual capacity. It is the Council of Ministers which will decide, not Parliament. The Governor acts on the aid and advice of the Council of Ministers. It is the Council of Ministers at the other end which will decide, not the legislature. It was to ensure that there is slow integration of Jammu and Kashmir into India through a process that is easy, through a process that will allow the executives communicating with each other to make sure that the Constitution of India, as applied to the Constitution of Jammu and Kashmir is put into effect. Which is why the CO in 52, in 54, that's the background. Once we decided on the list that this is the entry in the list on which a law can be made, and two executives agreed on it, a law is made and it will be applied. That's the procedure, Malaj. Nothing to do with how they have interpreted the Constitution. And that's how it happened all the time. Which is why, if your lordships will remember at the outset, I said, this is an exercise of executive power. It is not even exercise of legislative power. Far be it some quasi, some ancillary constituent power. Doesn't exist. Yeah, Malaj, I am asked this one question for which, Malaj, if you have an answer, Malaj, I certainly don't have an answer. Malaj, throughout, Gopalaswamy Iyengar, who was part of the drafting committee and who introduced the bill, understood 370 as we have argued before your lordships. Exactly that. From 1950 to 5th of August 2018, no member of parliament, no member of parliament, no individual in the public space said otherwise. Nobody said it. Every interpretation of the Constitution as reflected in the debates in Legislative Assembly and in Parliament interpreted the Constitution as Iyengar interpreted it and as we have argued before your lordships. There has never been a dissent. When the government of India files an affidavit in this court, it's the same thing, except they say that now through this process, we have substituted the Constituent Assembly with the Legislative Assembly. They have understood 370 in the same way. Now in the argument, not part of their affidavit, not part of their pleadings, they say, no, there is some plenary power. Your lordships are not sitting here in an advisory capacity to tell them as to what 370 means. We are, Malaj, testing the action of the union. We are not having some academic exercise of the interpretation of 370. We just to test CO 272 and 273. Whether it was rightly done or wrongly done. Maybe rightly done, maybe wrongly done, that your lordships will decide. But it has nothing to do with any plenary power, nor is it the case of the union. Now, let's accept their argument. Let's see, test it, Malaj, how it will be. They say, this is a plenary power. Forget the proviso because the Constituent Assembly is dead. There is no Constituent Assembly now. There is a Constitution of Jammu and Kashmir which is in place. And the argument is, now that it is dead, I can exercise that power and abrogate it. That's always been the position. So what it means is, Malaj, that the Constituent Assembly and the people of Jammu and Kashmir signed their death warrant on the day the Constitution was made and the Constituent Assembly was dissolved. On the next day, 370 could have been abrogated. Instead of 5th of August 2018, 19, they could have abrogated the next day. So they were signing the death warrant that while we are there, you can't do anything about it. But the moment we have drafted the Constitution of Jammu and Kashmir, then you can tomorrow just take away. Just abrogate 370. What is, can any constitutional court can never interpret 370 in this fashion? Can anybody even think about it, Malaj? That a Constituent Assembly drafting the Constitution of Jammu and Kashmir, saying that we are an integral part of India, taking note of 370 in the manner in which it is to be integrated into India, will say to themselves that the day we are not in place, it will be abrogated because there's a plenary power superior in 370, which is not there in 370, but because we say so, and which is not even part of the counter affidavit of this. This is not even the case of the union. What are we? Wait, this is not some I mean, this is not even. You look at it textually, you look at it contextually. There is no other conclusion you can come to. Now, your lordship asked me several times and asked others also, what's the way out? That's not for your lordships to decide. Your lordships are not here to tell them what the way out is, or for us to tell them what the way out is. It's a political process. The way out is a political process. Or some other process, that's for them to decide. But the way out is not this, that you do something consistent with the interpretation of 370 and you argue exactly something else, which has nothing to do with your own counter affidavit, and that's the union. How can they be allowed to do that, Manoj? What does concurrence mean? It means consent, as your lordship has been saying. If it requires the consent of the governor of the council, governor acting on the aid and advice of the council of ministers, where is that plenary power that we are talking about and reading in 370? And 370 sub-article 2 says that if an order is made, Malaks, between 1950 and 1951, when the Constituent Assembly was in place, the Constituent Assembly can reject it.
Mr. Sibal, why does the proviso to clause 3 use the expression recommendation when two other provisions in the same article use the expression concurrence?
Yes, sir. I'll give your lordship that.
B2 uses the expression concurrence, and the second proviso to D uses the expression concurrence.
Absolutely. In other words, Malaks, when it comes to applying the Constitution of India to Jammu and Kashmir in respect of in matters which are not with reference to the lists, Malaks, you need the concurrence of the state government acting on the aid and advice of the Council of Ministers. At least, Malaks, with that, there is no plenary power of Parliament. Concurrence means I can say no. Means an executive can say no to what is proposed. Now, if you read 370, and I just answer my Lord's question, if you read 370, the president's still notification cannot be initiated. Because the expression in the proviso to 370 are two expressions, necessary and before. The timing is set when it's before the president issues a notification, a recommendation has to come, and that is necessary. And the order in which is that the recommendation will come, then you would pass an order. You can't reverse that process on a plain language, on a textual reading, which I said, Mullahs, I accept what Mr. Salve said. Read the text and give the answer.
Mr. Sibal, is it not conceivable? I mean, I'm just thinking aloud.
Yes, sure.
That so long as Article 370 operated, it provided modalities for the application of the lists, the entries in the three lists, consultation in one case and concurrence in the other.
Right.
So long as Article 370 operated, it provided for the application of the other provisions of the Constitution, subject again
to the same process.
Same formula, consultation and concurrence.
Absolutely.
You probably rightly said that the object was to bring about a slow integration.
That's correct, which I've been saying.
In achieving that slow integration, the Constitution framers provided for consultation, this whole formula of consultation and concurrence.
Absolutely.
Checks and balances at two levels of government, the union government and the government of the state. But significantly, the Constitution doesn't tell us what would happen after the Constitution of Jammu and Kashmir would be framed. it contains no express provision that that constitution would then be embodied or incorporated in the Indian constitution. Because the Indian constitution, by all indicators, we've seen several indicators, was always to reign supreme. So when it came to abrogation, it left in 1950 the point of abrogation to the exercise of wise statesmanship. You just said a short while ago, why didn't they do it in 1950? If
No,
this
not a
inter-
question to do it. They had the power to do
They
it.
had the
I'm
power.
not on that.
You're right.
Yeah.
I mean, you're right.
Yeah.
Why did they not do it? They had the power to do it. If they had the power to do it,
Because they never understood 370 in this fashion.
no, there's an alternate hypothesis. It was always presumed that allow 370 to work out. There should be an eventual process of integration. Let that integration take place over a period of time, during which you will have this twofold procedural check of consultation and concurrence. At what point of time the integration is deemed to be complete, or that Jammu and Kashmir is ripe for an integration with the rest of India in the full and true sense of the term, was not hedged in by the constitution.
Mullahs, I'm sorry, with the greatest
Is that
respect.
not a possible?
No,
is
no,
that
it's
a
not,
possible?
it's not, Mullahs, on a plain reading of 370.
Because there are very significant silences in Article
No,
370.
Mullahs, you don't need expression of interest in this fashion for the simple reason that that 373 itself gives you a clue as to what was the reason
There are
behind it.
not sufficient silences in Article 370 to lead to the conclusion that the framers, both when they were on that side in the state of Jammu and Kashmir and on this side in the Union of India, left it to wise acts of statesmanship in 1950.
I hope on both sides, Mullahs.
Yes, of course.
Sybil, just
This was a
one-
unilateral act, Mullahs.
Oh,
This was not a wise act, it was a unilateral act.
just one, taking on what Chief Justice just said.
Yes.
It's quite apparent at that time what was either happening with the rulers and integration into India, because that was the objective. And it was all a political move at that time. There were different views expressed even with regard to J&K. If one looks at the wording of the articles, the argument of the other side was it was deliberately left very flexible and to some extent contradictory.
Yes. Mullahs, I don't see the flexibility here, Mullahs, neither I see the contradiction. Just read three with me, Mullahs. If you find, Mullahs, that there's a silence there about what would happen, Mullahs, certainly.
And except for the provision for permanent residence, Section 6, which finds its mirror image in Article 35A, every other provision was really a mirror image of the Indian Constitution. So what is that an indicator of?
That's an indicator of the
Indicator
fact
of
that
whatever is happening there is really the incorporation or the adoption of what is happening in the
I can only say this to your
constitution
lordship. I can only say
of the Union of India.
I can only say this to your lordship, Mullahs, either we interpret 370 sub-article 3 in its text and context, or we find something that's not there. And as a matter of constitutional law, Mullahs, you have to interpret the Constitution, not find a silence in the Constitution to interpret something that is expressed. Let's just read it, Mullahs. Notwithstanding anything in the foregoing provisions of this article, the President may, now who is the President? Acting on the aid and advice of Council of Ministers, may by public notification declare that this article shall cease to be operative, or shall be operative only with such exceptions and modifications and from such date as he may specify. Now just pause here. Supposing, Mullahs, he was not to abrogate, who is only to modify or apply with exceptions. Is that also unilateral power? Forget about abrogation for the moment. So we have to interpret constitutional provisions as we read them, Mullahs, not as we find some element of silence which is not there. provided that the recommendation of the this is a proviso, Manoj. That the recommendation of the Constituent Assembly of the state referred to in clause 2 shall be necessary. That means to start the initiation of the process, that recommendation is necessary. And before the president issues the notification. It's a double emphasis of how that power can be exercised, not by parliament, but on the aid and advice of the government. So, Manoj,
We'll of course have to then, to accept your argument, we will have to read a further condition in the proviso that the recommendation of the Constituent Assembly has to be in the same terms of the action which is proposed to be taken by the President. Namely, either that if you are abrogating, there must be a recommendation that yes, abrogate.
yes,
Or if you are making 370 applicable subject to such
yes,
changes,
same thing.
then the recommendation must be also along the same.
Yes, yes,
But
absolutely.
that's not there in the proviso, isn't it?
It is, Manoj, it is, before any of this. Kindly see, provided that the recommendation of the referred to in clause 2 shall be necessary.
Look, this is a core argument on which you have taken one stand, the other side is
That's
taking
what we have to-
another stand. We'll have to.
we have to-
No, all I'm saying, Manoj, at the moment is, Manoj,
What their stand is that proviso will not evaporate and write off the third clause of Article 370 after the Constituent Assembly as.
Manoj, at least it's so
That's their
far,
stand. Your
so
stand
far,
is to the contrary.
so far, Manoj, I can only go by precedent. So far, the proviso has never been interpreted in the fashion that they are seeking to interpret. In any judgment of the Supreme Court since
That
1950.
occasion never arose, probably.
That's not the way they acted. Manoj, kindly please appreciate what they've
And
done.
therefore, according to you then, if the proviso cannot be applied because the Constituent Assembly has come to an end,
No, Manoj, with respect, I say, that's not the point.
because the proviso says the Constituent Assembly referred to in clause 2.
Correct.
So it is only one Constituent Assembly which was formed for the purpose of the framing of the Constitution of J&K.
Correct.
Even if you have another Constituent Assembly in J&K, you can never have that Constituent Assembly which was for the forming the
No,
Constitution.
Manoj, let me answer.
Therefore, the proviso
Let
cannot
me-
apply at all
Let me answer it.
in your submission.
Yes, yes. My answer is the following, Manoj. When the Constitution of India was framed in 26th of January 1950, there was no Constituent Assembly and there was no Legislative Assembly. So what did, Manoj, the Constitution makers provide for in the proviso? They envisaged that there would be a Constituent Assembly. They envisaged that there would be a legislature. If there was a Constituent Assembly which would abrogate 370, there would be no Jammu and Kashmir legislation. Constitution, there would be no Jammu and Kashmir Constitution. Because that's abrogation. Constituent Assembly would recommend abrogation. At that point in time, those who drafted the Constitution were not aware as to what was going to happen. That's why. Sorry. I'm sorry.
370 in the slide, there are two arguments. One, obviously, with reference that the proviso will not be controlling the main part of 3. That's the core dispute between them.
That's right.
Provision will not be applicable is contradiction in terms.
Now, Manoj, let's put it differently. Manoj, this whole process was a political process. That's what Salve argued, council argued. This is a political compromise. So you pull the plug anytime you want to pull the plug. At least 370 doesn't allow you to do that, but assume that's the case. If it's a political compromise, there will be a political solution. Why are lordships finding some constitutional solution that doesn't fit into this? That's not what your law, Malad. You have to, please look at it this way, Malad. If the process was political, the solution has to be political. Now, how that solution comes about is not neither for your lordships, not for us to suggest. This is something that they have to do in
Initial part-
collaboration.
The initial part was political, now it has to be constitutional.
No, Malad, if that is so, Malad, if now it's constitutional, then that means that the
While
Constituent
keeping in
Assembly.
mind, while
Just look at
keeping
it
in
this way.
mind, the fact that the intent behind the article was temporary and transitory. in
But
nature.
that I'll come to a little later, but Malad, the answer to the question is that the Constituent Assembly was framing the Constitution of Jammu and Kashmir, knew that after that task was over, it would end, and was signing a death warrant under 370 sub-article 3, that now you can abrogate the Constitution. Well, that can't, I'm sorry, Malad, on a plain reading of 370, I have the greatest respect for your lordship.
Therefore, the sequitur of your submission on the proviso to clause 3 is that once the Constituent Assembly has formulated the constitution of J&K, which has been adopted,
Yes,
the proviso ceases to have any existence.
yes, and 370 ceases to have effect.
Therefore, 370.
370 ceases to have effect. 3 has ceases to have effect.
Sorry, 370 or.
Sub-article 3 ceases
Right.
to have.
Therefore, 370
Yes.
bracket 3 ceases to have effect.
Yes.
In which case, 370 by itself, apart from 370 clause 3, assumes a permanent character.
It's permanent in the sense that, well, what is left of this autonomy that we are talking about? If the argument is it is just a shell, what is it that you're trying to do? What is the argument today, Malad? I've heard it, Malad, several times over. What is left is only a shell. Everything is already there.
That there's a contradiction in their argument.
Well,
on
I'm
that.
only saying, Malad, sir.
Just one.
Yeah.
There's a contradiction in the argument. They said that main substantial part of the constitution, including 356, is now fully applicable. But what was the main stumbling block was section 6 and 35.
Because as far as 35 is
Therefore,
concerned, that's a separate issue.
No, I'm not interpreting. Complete adoption of the Indian constitution in toto, in completely as in case of other states.
Strike down 35A. Well, I don't understand where we are getting here. If this is the only stumbling block, you strike down 35A.
That's the judicial way.
No,
The
that can't be politically done in any case. Because there can be reasonable restrictions and there can be classifications in terms of Article 14. It has happened in Uttarakhand, it has happened in Himachal, it has happened in other states, Malaj. It can't happen in Kashmir. Malaj, it is happening in Assam. You are fixing a date
We'll come
to
to that
people who
little
came
later.
into Assam.
We'll come to that little later.
Malaj, I'm only trying to, Malaj, indicate, show the mirror to myself that if it happens in Kashmir.
Well, there's actually, I feel, the two spectrums which have to be decided.
Yeah.
When you use the word temporary, whether it's actually temporary in the sense they understand it, or it is temporary in the sense you understand it, that it was with the context of the Constituent Assembly, one. Number two, how you understand subclause 3 is that once the Constituent Assembly dissolves itself, 370 in the form it exists according to you is frozen in time for all times to come. Correct? This is what your argument is.
No, 370 sub-article 3, Malaj. The rest of it is still remaining.
Yes, I'm saying 370, the remaining part is frozen as period of time because of the historical perspective.
No, not remaining, Malaj. You can continue to integrate. 3 is frozen.
3 goes to remaining
Absolutely.
part subsidy.
Yeah, absolutely.
They say no, 373 is not limited to that stage because of the manner COs have been issued and can extinguish themselves.
That
This is a
COs have been
fundamental
issued in, not in under 3.
Then comes the methodology, whether they could have done it or not. That's
Well,
like
the
a slim
COs
box.
have not been issued under 3. This is the problem, Malaj. These COs can continue to be issued. All of them are under 1. So, and Malaj, I'm sorry to say this, when you talk of temporary provisions, it is not a temporary provision. Kindly
Mr.
look at-
Sibal, ultimately, therefore, it will boil down to this, that there is in our constitution, if we accept your submission, there is in our constitution a provision to which even the amending power, which is available in respect of the rest of the constitution, is unavailable.
It's unavailable because it's been amended. 368 has been amended with a proviso.
And there is, in that sense, a provision of the constitution which lies even above the basic structure of the constitution.
No, my lords, I mean, why do your
Because you
lordship say
cannot,
it is?
370 you can't amend also.
I'm sorry.
You can't amend 370 also.
It's not
To
a.
amend 370, you have to take the route of 368, and 368 takes you
Well,
back to
well-
371 by the proviso. Therefore, we would be then really accepting a situation. We're not saying it's unstateable. We are testing the proposition. Is there a part of the Constitution? The only restriction we have found so far in our jurisprudence on the power of changing the altering the Constitution is a basic feature doctrine. We are now going to add one more, which is that Article 370 lay even beyond Article 368,
No,
and much
but
beyond the
let-
basic structure doctrine, because you can't touch Article 370. It assumes a character of permanence.
Well, this is getting
Isn't
more
that-
interesting. This is even getting more interesting. Well, let me now ask myself a question. Supposing I were to file a petition tomorrow in this court that the proviso to 368 is unconstitutional. 368 too. Supposing I were to file the petition. And what my lord is saying is upheld, is right. That how can you do that? Strike down the proviso to 368 and amend it under 368. There are hundreds of ways of doing the same thing, Manoj, but we are testing the proposition in the context of what they have done. What they've-
The postulate that in the exercise of judicial review.
But
will
your lordships
strike
are
down.
putting to me.
We must take the proviso as a given.
But I am saying, yes, Manoj, it's your lordships who are saying there's something silent in it, which I don't see, Manoj. I don't see the silence in that proviso where the perpetuity of a presidential notification can be issued at any time, even after, Manoj, even.
Because the two plain consequences of your submission are first, once 370 clause 3 goes out of operation for all intents and purposes, 371 and 2 have a permanent character in the Constitution.
2 is not there, Manoj, 2 is not there.
Right, two is of course, yes, after the
Yes,
Constitution.
yes.
371 has a permanent character in the
That's correct.
Constitution. Second, you cannot amend 370 using the 368 power because of the restraint which is imposed by the proviso, which again takes you back to 370.
Kindly see.
Therefore, even the power to amend 370 is within the fold of 370 and not
Let
368.
let me, Manoj, let me answer that also, straight away, Manoj.
So we are carving out really a provision of the Constitution
see,
which
but it's-
lies even higher than the basic features
No,
doctrine.
no, no, Manoj,
Isn't
that
the
your
plain
lordship should not
consequence?
say, Manoj, because that's not yet tested. That your lordship should not say, that's not tested yet, whether it's higher than the basic feature of the Constitution or not, Manoj. But kindly see, this was added in the 1954 order, Manoj. The proviso to 368(2) was brought in by the order, as well as, Manoj, the proviso to Article 3 in 1954. Who brought it, Manoj? The government of India. State of Jammu Kashmir did not. They gave its consent to it. Why did they do it? Because they did not want 370 to be tampered with. I'm not saying this, Manoj. I am talking of the intent of the government of India. When the proviso was added, both to 3 and 368. Not my intent. And your lordships are now saying, what is the intent of the government of India? It was made clear that even under 368, you can't do this. Government is a continuum. Kindly, Millers, appreciate that. It is not something that was done by Jammu Kashmir on their own. I understand, Millers, and there we go into the sentiment argument, the emotive argument. The argument that Mr. Dwivedi made, with respect. That we appreciate the sentiments of people of Jammu and Kashmir, but there are sentiments in India. Whereas with the greatest respect, I humbly pray that we are dealing with the Constitution. Whereas it's a sentimental thing. I also have sentiments with a lot of things. But when we come to court, we discard do away with what our heart, the nature of our heartbeat, and come to brass tacks rather than interpret the Constitution. You can pepper it with emotive instincts, Mullahs, but you can't get away from the plain language. And my respectful summation to your lordships is a political process must have a political solution. And as I said, what is left of 370? There is no residuary power with the, we talk about residuary. What is the residuary power? There's no residuary power with the state. When did the state ever exercise residuary power? So for all intents and purposes, it is fully integrated.
In other words, according to you, there is no solution to Kashmir
No.
within the constitution. Devise a
No,
solution
Manoj.
outside the
Why,
constitution. That's
now
what
your
you are
lordships
saying.
are putting this to me. Manoj,
Ultimately, that's
No,
your,
no, no,
that's
that's
your,
not what I've argued.
that's the
That's-
hypothesis, that the solution has to be political outside the constitution.
it is a problem looking for a solution, and your lordships don't have to provide that solution, is what I'm saying.
All solutions have to be within the framework of a
It
constitution.
is within the framework, Manoj. It is within the, who says it's not within the framework? Well, isn't 370 a classic form of federalism? Unlinked to the federalism that we practice? It's a classic form of federalism. There's nothing unconstitutional
There
about it.
can be a lot of arguments on the other side. Let's not go into all that, whether
No, I'm just saying.
Are you
I'm
saying-
saying, Millet, it is not unheard of. It is not something that is so utterly unthinkable that a state can have a certain special status.
If you go by Dr. Ambedkar's adoption speech, it's quite clear that he wanted a unitary form, primarily unitary
is
form
unit.
with certain federal
It is
features.
unitary, Millet. Who says it is not
That's very
unitary?
clear, and there's
This-
historical
and Manoj,
reasons. And let's not go into the historical.
Ambedkar said an also very important thing. Way Jammu and Kashmir. He said that, say something, just come to my mind, Manoj, I've skipped. No, that's not what he said. That equality is in your mind. The equality, all people in this country are equal. Some are not considered equal, that's all. That applies not just to Jammu and Kashmir, that applies to a lot of places in India. So let's not go that route. Well, just because it's a union doesn't mean we are not federal. We are a quasi-federation is what we are. And that's what Ambedkar said, that we're a quasi-federation. But Manoj, quite apart from that, that's how all members of parliament since 1950 have understood it. Manoj, why are we, that's not their case. We are trying to find a solution, which is not the case of the Union of India.
Civil, Dr. Ambedkar in his speech, both speeches, 4th of November 1948, as well as 25th of November 1949, he has distinguished the American Federation with
Yes.
our federal structure, and he has specifically stated that in America, there is a citizenship of the Federation as well as the state citizenship, and it permits two constitutions, the state constitution as well as
Correct,
the federal constitution.
correct.
But in India, we have adopted a single constitution and single citizenship.
Absolutely, right, Manoj, but kindly look at it this way. It is this constituent assembly that approved 370, of which Ambedkar ji was a part.
So therefore, the question will be whether it was a temporary measure.
No, this is what
the
the Constituent Assembly said. This is what Manoj, the cabinet said. This is what the government said. This is what the government has been interpreting 370. This is what they have done, Manoj, in the light of the interpretation of 370, as we have placed it before your lordships. What is 272? To replace the Constituent Assembly with the Legislative Assembly. That is trying to implement the proviso, no? They've used the proviso. Now they are arguing just to the contrary. How can your lordships even allow them to do that? We are testing, Manoj, we are testing the process. We are not testing the power. We are testing the process. And the process adopted by them is the 370 sub-article 3 process. They have substituted Constituent Assembly to Legislative Assembly. Then they have imposed 356 and Parliament has become the Legislative Assembly and given consent to itself. plenary power or any silence in 370 which allows them to do what they wanted to do. That's not their case. So we are now adjudicating a case which they have not pleaded before your lordships. If some private citizen were to do that, would your lordship ever allow it?
So, Mr. Sibal, you are saying 373 doesn't exist practically. Correct? That's your argument. Their argument is 373 exists and we've taken that.
No, they
Whether
say
the
370.
process- That's the second part. Whether the process applied by them under 373, if it exists, is the proper process as per 373 or not, is the second limb of the.
But Maharaj, I'm saying something else to your lordships. They proceed on the basis that 370 exists.
Correct.
Therefore, therefore, they are not saying that 370 doesn't exist after the Constituent Assembly was drafted and nothing else happened and there's no Constituent Assembly. It's not their case. We are now, we are now adjudicating upon a case which is not the case of the Union of India before your lordships.
Many things have been said, Mr. Sibal, from both sides, which are really not, in our view, prima facie germane to the main issue is this of 370, as you say, one side of the argument that with the Constituent Assembly going away, 373 really did not subsist, only 371 survives. Their view is that 373 subsists and that's the route we have adopted. Second limb arises if 373 exists and the route they've adopted, what's the correct route, permissible or not?
But that's what I'm arguing. When I opened, I only argued on the route. If your lordships will remember, I never went into any political argument, any historical context.
So that is your argument that.
I never talked about lack of sovereignty. I never talked about federalism. I never talked of any of that. I said this is the process they have adopted and this process is unconstitutional.
I remember you also said that it's not for us to, or for you, or for to suggest what is the alternative.
Exactly.
Then when an alternative route is followed, it will be tested in its own way. But
Correct.
this is the route they have adopted.
And
They've
that,
not taken a 368 route. They've
That's
taken
correct.
a 373 route.
so the first question that your lordships have to answer is 272 valid or not? And
That
to-
we'll have to decide.
Yes, and
That
that can't be
argument
decided.
decide.
That can't be decided because that they have followed the route of 370 proviso, Manoj. It is their case.
Yes, yes.
So the problem there with the argument is that 370 can't be decided in the context of the argument now raised. That after the Constituent Assembly is not there, we can do what we like. But that's not what their case before the court is. Their case is that they have applied the proviso and substituted Constituent Assembly for Legislative Assembly.
That's what the CO says.
That's right. So you have to test only that, which is what I argued. I didn't argue anything else.
We are not asking you to argue beyond it.
No, they have forced me to argue beyond it. They have forced me to argue beyond it. But let me go back a
Even
little.
assuming that they have followed the route of the proviso to 373, I don't think we can prevent them from sustaining the exercise of power on the ground that even independent of that, we are entitled to.
That's not in their counter. I'm sorry, Manoj, that's not their case. I'm sorry, you read your counter. It's a sweet. With me as to what they say.
They meant 367.
No, Manoj, in exercise of the powers under clause 1 of 370.
Absolutely.
So, Manoj, they are saying that, and then they say the proviso.
That was for incorporating the proviso.
But I'm only saying that they are.
Sorry, 367 to the, that was for amendment to the 366.
That's what I'm
But
saying.
ultimately, then they invoke the power under 370 clause 3.
With the proviso, Malad.
Yes, with the proviso.
But that's all I am saying,
the
Malad. I'm saying nothing more than that. That's the
We have
problem.
understood your argument on that.
Yeah,
You
I'm just saying,
In
Malad.
fact, we had put that question to the Attorney General also.
You also given the answer, Malad. This is a sui generis provision of the Constitution, must be interpreted in its own terms. That's all that I'm saying, Malad, and kindly
Well, I
take a
think
counter.
this part, I think we've conceptualized, we've put our doubts to you, you've conceptualized your
Giving
answer
life
as
to
well.
373 through Article 367. That's their counter. That's all that we are testing, Malad. Okay, so Malad, that's done. That's done, Malad. I'm done with that. Now, Malad, kindly go back to, no, now kindly go back to the list of dates, and just orally, Malad, I'll mention to your lordships. 20th of June, in 2018, well, that's 19th of June, BJP withdrew support. 20th of June, Governor Malad puts the assembly in suspended animation.
Now, the latter part, now you are going into the.
I'm going to test
356.
356.
356.
356, right? And the dissolution of the assembly on 19th of December, on 21st of November 2018. Now, Malaj, the normal process is, Malaj, for the governor has the power to keep the assembly under suspended animation without the aid and advice of the Council of Ministers. That power is given under 92 of the Jammu Kashmir Constitution, which he did.
Which?
Which he did, Malaj, on 20th of June 2018. Now, Malaj, the Jammu Kashmir Constitution also says that this will last only for 6 months. That such a decision of the governor will last only for 6 months. That is set out in Article 92, subclause 3. Sorry, Section 92, subclause 3. That such an order will last only for 6 months. Now, which means by 19th of December, there should have been revival of the assembly. Because the assembly was not dissolved. See the political motives and the illegality in the whole process. This can't go beyond 6 months, beyond 19th December. So he has to revive the assembly. There's no dissolution. So on 19th December, he dissolves the assembly. On 21st November, he dissolved the assembly. Now, dissolution can't take place without the aid and advice of Council of Ministers. Section 53 of the Jammu Kashmir Constitution. Section 36, 38 and 92 are the only exceptions under the Jammu Kashmir Constitution. I mentioned it earlier also, where the governor can act on his own. But 53 is not. 35, 38 and 92. 30. So, Malaj, he could not have dissolved. And after dissolution, 356 can't be imposed. After Malaj's dissolution, Article 356 cannot be imposed. These are Constitution bench judgments of this court. Now, your lordships asked me the question last time also, you've been asking other council also, why did you not challenge it? Number we could not challenge as far as the governor's order of 20th June is concerned, because under the constitution of Jammu Kashmir, he had to put the government back in place within 6 months. Where was the occasion to challenge it? Council of Ministers would have been back in place.
What would happen if there's no conceivable government formation possible?
Whereas he can't do it, that's the point.
Mr. Sibal, that's little saying that because it was tenure or 6 months, I can't challenge this wrong.
No, I said, I
Certainly
haven't
can't-
challenged it.
You can't challenge it. You
Not,
can say
I'm
you
not,
can't.
I can't, when I said I can't, I mean, we knew, Malas,
No,
that
you
there,
can certainly challenge it, and you do, people do challenge
they
it.
do, but Malas, the government was to come back in place, Malas, was to be put back in.
That may be little,
The government was to be put back in place within 6 months, Malas.
My only question is how, if in 6 months, no government is feasible, possible, then necessity would require a resolution, would it not? What
I'm
would
sorry?
happen? Let us say there is no government possible. Then whom will he put back in? What kind of governors?
So
Government?
Malas, what you do is you impose 356, then you dissolve. With the process of under 356, Malas, I've explained it last time also, that you keep the assembly under suspended animation. You see if you can form a government or not, because 356 is a temporary provision to restore democracy. If you find that there is no possibility, after imposing 356, you dissolve and hold elections. That's the process.
So then the dissolution should have taken place under the rubric of Article 356.
That's correct. That's correct. And that's a constitutional bench judgment. I'll show that to your lordship straight away. Just keep that judgment. Document volume 19, sorry, case law compilation. PDF 232. This is, well, the constitutional bench judgment in the matter of special reference 1 of
Case law
2000.
compilation.
Compilation 19, volume 19, well, it's case law compilation 19. Yeah.
Page?
And the relevant part,
What is the page, Mr. Sibal?
well, it starts at 232, PDF 232, relevant is 313. And I've been saying this from day one. This was the political process. The intent was entirely political and the means were entirely unconstitutional. Oh, sorry.
Draft Assembly?
313 minutes. Para 135.
Paragraph?
135.
Volume 19.
Yes, volume 19, case law, volume 19.
ये तो कोई BSNL का judgment. अच्छा अच्छा.
Assembly election matter.
That's correct. Para 135.
So it appears the page 300 and
318 it says, but the PDF is 313. The running page is 318.
PDF is?
313. Paragraph 135. My lords have it, man?
Yes.
My Lord Justice Call doesn't seem to have it. You have it. May I read it, Manas? Dissolution brings a legislative body to an end. It essentially terminates the life of such body and is followed by constitution of a new body, legislative assembly or house of a people, as the case may be. Prorogation, on the other hand, relates to termination of a session and thus precludes another session, unless it coincides with the end of the legislative term. The basic difference is that prorogation, unlike dissolution, does not affect the legislative body's life, which may continue from session to session until brought to an end by dissolution. Dissolution draws the final curtain upon the House. Once the House is dissolved, it becomes irrevocable. There is no power to recall the order of dissolution and or revive the previous house. Consequently, effect of dissolution is absolute and irrevocable. It has been described by some learned authors that dissolution passes a sponge over the parliamentary slate. The effect of dissolution is in essence termination of the current business of the legislative body. In its sittings and sessions, there is cessation of chain of succession, sittings for a dissolved legislative body, and there cannot be any next session or its first sitting. With the election of the legislative body, a new chapter comes into operation. Till that is done, the sine qua non of responsible government accountability is non-existent. Consequently, the time dissolution is non-existent. Stipulation is non-existent. Any other interpretation would render use of the word "its" in relation to the last sitting of one session, the first sitting in the next session without dissolution. Right, Melissa? Now 319. Para 156. Now come to 356. What the court says on 356. PDF page 319. Lord has 156. Justice Gawai.
Yes.
So far as the applicability of 356 is concerned, though in the order of election commission has specifically dealt with the possibility of applying that situation, in the written submissions and the arguments made before this court, the view was given a go by. And in our view, rightly, mere non-compliance with Article 174, so far as the time period is concerned, does not automatically bring in Article 356. It is made clear that an order of the election commissioner is the foundation and not what is stated subsequently by way of an affidavit or submissions to clarify. But in view of the concession, which according to us is well-founded, we need not go into the question in detail. It is submitted that by some of the learned counsel that the election commission's order otherwise makes out a case of applying 356 when the requirement of 174 is not met. In Thiru Rajagopal versus Karnanidhi, a constitution bench of this court said, Article 356 of the Constitution makes provisions in the case of failure of constitutional machinery in the state, but when the assembly is dissolved, there is no failure of the constitutional machinery within 356. Because the governor was ruling for 6 months, where is the question of 356? So you do it this way, tell the governor, whereas he sort of puts it in suspended animation, less the 6 months almost part when the government, when the two parties say that, look, we are ready to form the government, but that's not proved, Malaj. Then on 19th December, President rule is imposed after the assembly is dissolved on 21st of November. Couldn't be done. Then if that's bad, and that has to be decided by this court, because that's the basis of 202, 272 and 273. So whether we challenge it or not, that's the very basis. I will. What more do you want me to read?
that this can happen, right? Because the section 92 power is sui generis.
Yes,
Normally, even when an
he has to
assembly,
act on the agent advice, no.
normally when an assembly is placed under suspended animation, as we call it, that's also an exercise of the 356 power.
Yes, that's on the recommendation of the governor, Malad.
That's on the recommendation of the
Of
government.
the governor, that it can't be carried on in accordance with the provisions of the constitution. Then 356 is, well, that's what happened.
And the recommendation of the governor again is on aid and advice, or that would not be on aid and advice?
No, no, it never is.
It will never be
It
on aid.
never is.
So
No
government
question
will tell
doesn't
the
arise.
president. So we are just wondering, according to you, the dissolution of the assembly on 19th of December is wrong, 19th of November is wrong, because it had to be by
21st November, yeah, 21st.
25th of November is wrong.
21st November, yeah.
Because there had to be aid and advice. There was no aid and advice.
Apart from that, Malads, where was the occasion for 356 at all? Because he was running the administration. Malads, he's running the administration. There cannot be a constitutional failure. That happens only when the government cannot run in accordance with the provisions of the constitution.
But therefore, no, but we're just testing it like this. Suppose the governor's dissolution is, according to you, incorrect. The consequence would be that at the end of 6 months, the legislative assembly has to be restored.
No, no.
The suspension would come to an end after
After
6
6 months,
Yes. Then
If
then the
the
council of
suspension-
ministers have to be,
Council of Ministers has to be formed.
correct.
Now, taking your argument to the logical conclusion that, look, the dissolution was wrong and the governor had to necessarily at the end of 6 months
Before.
restore, before 6 months, restore the legislative assembly,
Yeah.
lift the suspended animation,
Yes.
invite a government. In which case, can the government of India not have then exercised, the president not have exercised the power under 350?
Correct. So then he would have had to make a recommendation that this is not, they are not functioning in accordance with the provisions of the constitution because the governor was ruling for 6 months. Where is the occasion, Malas, for him to at that time exercise that power?
But if no state government is possible, nobody is agreeing to combine together.
But that's fine, Malas,
Keep the facts aside.
in which you impose 356. Don't dissolve it. Well, that's the whole problem. You impose 356.
And keep the assembly in suspended animation.
That's always the case. I'll give you several notifications. I don't have the time. That's always the case. What you do is you keep the assembly under suspended animation. You try and, you have to restore democracy. So at some stage you feel that now it's time to hold elections. You dissolve the assembly and announce elections. That's the process followed in every 356 proclamation. You never dissolve the assembly immediately, but then you have to hold elections. Well, the democratic process can't be stultified, can't be used in this fashion. Because this was, as I said, this is a political decision. It has nothing to do with the constitution. I've been saying that from day one, Malas. These are political decisions. Even 272, 273 is political. Maybe I'll.
How much more time now?
Well, not too much, Malas. I want others also to argue, but I've been trying to sort of not even refer to anything and just argue orally, Malas.
Because last day, because
Malas, your lordship, this is, Malas, we are trying to do it as quickly as possible, but your lordship is always very kind. Let me not make any suggestion today. Let me, Malas, argue tomorrow.
we'll have to wrap up tomorrow. We don't mind extending a little bit for half an hour or so tomorrow. But we'll
I
have
will
to
try
wrap
and
up.
finish as quickly as possible, Malas.
So just do make sure that everybody rations.
Yes,
time
yes,
for that.
that's my whole, Malas, intent.